Le dernier exposé qui sera présenté par Céline Romainville et LÉNA GERON.
The presentation by Céline Romainville and LÉNA GERON, were the co-organizers of this network. LÉNA GERON is a PhD student at the Public Law Center of the University of Liège, a research which is carrying out under the supervision of Frédéric Bouon, focuses on the study of the relationship of trust between members of parliament and their representatives in Belgian constitutional law, and examines how the issue of trust has reshaped the parliamentary mandate by driving legislative changes in the light of imperatives such as ethics, professional conduct, and the need to bring elected representatives closer to those they represent. And LÉNA GERON was also one of my students, by the way. She is a student, sorry, I've already mentioned that. I'm going to say a bit more about Céline Romainville, Professor of Constitutional Law at the Catholic University of Louvain, co-director of the Center for Research on the State and the Constitution at the University's Faculty of Law. She teaches constitutional law and the law of fundamental rights. Her doctoral thesis was devoted to the right to take part in cultural life and cultural policies in constitutional law and international law, and is subject has led to the definition of a legal regime for fundamental rights and a new understanding of the link between the concept of fundamental right and fundamental policy. The title of your exposé is Trust in Political Institutions, the Role of Public Law.
So today we are finishing a book. We're trying to finish it. And the objective is to offer some elements on the theory of trust in constitutional institutions. So this is work in progress. So all your feedback will be welcome. And we're going to test here some assumptions for this book that should be published in the future rather than presenting definite conclusions. The other objective of this is to look at the scope of trust in constitutional matters and to look at constitutional law in terms of trust practices. As Professor Barradas reminded us, this is an empirical research. So this is quite a broad topic, and Professor Loughlin highlighted that the authors often just say that trust is key, fundamental, but without going any further and without specifying the role of this notion in constitutional law and in the constitutionalism theories. So we needed to find a different approach and to mobilize social and political sciences. That was necessary to map the trust relationship in constitutional law and then to turn them into issues. So the contribution of democratical contributions was key to us, and Professor Loughlin demonstrated this earlier on. In the absence of autonomous judicial legal theories, legal experts use democratic theories, both normative and more explanatory democratic theories. So I will not come back to the state-of-the-art, to the stock count that we've done on the issue of trust in political institutions, and I will not come back on the connections between trust and democracy. I am referring to what we have written and the excellent contributions we've heard before. But we have to keep in mind for the rest of our speech some elements on how to position the issue of trust and democracy. So with the idea of people's sovereignty, the relationship between trust and political powers will be rethought again. So indeed, we cannot imagine power in connection with a trust placed in an individual without any limits, and the notion of democratic legitimacy that would phase out the notion of trust. And yet, this is not a total eclipse, and it's never been. Finally, the theories of democracies maintain some ambiguous relationship with trust, and when we slightly mentioned that. So on the one hand, they are built on distrust assumption towards political powers, which is the characteristic of liberal democracy, as Pierre Causan-Malon demonstrated in Contre-démocratie and other authors. Of course, it is the distrust and the suspicion towards the power that are at the core of democratic powers that are thought especially as control institutions. But despite focusing on this trust, the democratic theories prescribe some trust in political systems, or at least make that assumption to form and maintain a government. So trust seems to be a practical need essential to maintaining some regime, as the others only can maintain themselves by using coercion or the power of force. A certain trust in the respect of some political ethics is a practical need, and Jelinek, in his Théorie générale de l'État, developed this thing at the end, reminding that everything he said cannot be maintained if there is no political ethics. So I would like to go deeper into two questions. First, the fact that the trust relationship has always been key in the representative government, and the link between trust and responsibility. First, the trust relationship in the representative government has a new object. Bernard Manin explained the trust relationship in representative regimes. The trust relationship is more direct. It represents the trust in a particular person who has been identified. So this is interpersonal trust. With the emergence of political parties, the trust relationship is transformed. The represented chooses a representative because it's a member of a community, a political party, and places their trust into this person. Bernard Manin writes that we have a public democracy, even if it has changed a bit, where the image reflected by the media is key, which triggers a personalization again of this trust relationship and the reemergence of the trustee embodiment, and because of some personal characteristics. That's for the descriptive explanatory theories. But in the normative theories of representation, trust is not as developed in Manin's theory, for example, when he defines representation as a relationship that in an institution that has to control, sanction, but represent also, there's no trust. And then trust and responsibility. Trust links power to responsibility. The object of political responsibility is what defines the limits of power, and it is the trust of the elected assembly in a parliamentary regime, and this is what we are focusing on, of the elected assembly towards the government, and especially the persistence of the will of those to govern and those governed. More broadly, the political responsibility is thought as an imputation mechanism that should be considered as taking on the function of guaranteeing in a general way the trust of the public. And it was written that the sound functioning of the system demands the political responsibility, which is often the responsibility of others. So the gross expression of the link between trust, political responsibility, and power is the rule according to which the loss of trust in the parliament should force them to resign. On a different field, there is the trust presumption in parliamentary regime. The trust is described as a practical relationship of cooperation between the parliament and the cabinets that is based on the common need of proposing and adopting laws. And in parentheses, even in presidential regimes, trust is still at the core of the relationship with the executive powers. So in the impeachment procedure in the U.S., what the violation of the charge of trust of the president leads to this impeachment procedure. So the end of the British Constitution is to make a respectable man walk into the 10 Downing Street is looking for the trust in the government and some form of the possibility of governing. So that's a brief reminder. And now I'm going to move on to the two questions that we're going to tackle more specifically. First, conceptualizing the trust relationship in constitutional law to find out what is the object of this relationship. And secondly, the potential of constitutional law in producing trust. So we will limit ourselves, so to speak, to three trust relationships: the one between representatives and represented, between the parliament and the government, and between the governments and those governed. And I'm going to give the floor to Lena for the first part. Thank you, Céline. So for the first trust relationship that I will look at in constitutional law is the one that brings together the representatives to the represented. And as Céline said, in constitutional law, we're going to see how the object of this relationship is formalized. In reality, the constitutional law concerning the object of this trust relationship will exclude the imperative mandate and the mandatory values, that is the object of this trust that the represented give to the representative cannot be electoral promises or programs. Of course, these electoral promises, these programs do exist, but the constitutional law do not allow the disrespect of this to be sanctioned. So as a result, the elected representatives have to deliberate in the for the greater good of the people. So they have to make decisions in the greater good. So this is how Article 42 of our Belgian Constitution sets out that the members of the two chambers represent the nation and not just those who have elected them. Beyond that, the constitutional law doesn't seem to bring much answers to this object of trust. But we can see, especially in Belgium, but this is also true in other democracies, that for about 30 years, constitutional law will look at the object of trust of those represented by prescribing some conducts, behaviors of the elected representatives in order to restore trust. In reality, this is a research topic that I've been studying in my thesis for some years now. In other words, through standards that can be different, constitutional, legislative, or assembly regulations, the constitutional law redefines the parliamentary mandate. And in my research, I've seen that it goes through three vectors at least for this trust. So we can mention the role model of the parliament members, their availability and their proximity. So a few words for each of these factors. For the role model of that we try to impose to elected representatives through standards. We'll talk about this afternoon on this political ethics and standards. So we'll talk about that this afternoon. Eric Buge will be in that panel, and he tells us that it is all the rules that impose to the governing people some rules and encourages those governing to adopt virtues. And there's also a call to strengthened control, checks and controls to make sure that they act for the greater good. As an example of these rules of lower models, there are rules for remunerations and diverse advantages they may get, and the scandals we've seen over the past few years, rules aiming at enhancing transparency. The MPs have to declare all their mandates and remunerations, conflicts of interest through incompatibilities, lobbying activities, and so on. Second vector of trust that they're working on is availability. So here we usually focus on the ability to elected representatives to fully commit to the missions that have been entrusted to them. We need to make sure that those elected representatives focus on their work. And we could mention also incompatibilities here that could force elected representatives to renounce to some mandates to focus on the ones they keep. There are also rules to fight absenteeism in the parliament by reducing the remunerating of the MPs depending on the number of days they were absent. And last vector of trust is proximity. It can be understood different ways. First, proximity in the sense of a better representativity of the elected representatives. So they would adopt standards that would increase the presence of some categories of the population in the assemblies, for example, in enhancing the representation of women within assemblies. Second meaning is a geographical meaning of proximity. So reforms concerning the electoral constituencies, and also some standards that aim at framing the direct contact between elected representatives and the citizens. In Belgium, it's called représentation sociale. Another way of seeing proximity is a more direct proximity of elected representatives to public affairs. So there can be eligibility rules by participatory democracy rules. You've heard about this. People's consultation, referendums that are not possible in Belgium, or other participation and deliberation mechanisms for the citizens. The effects of these rules are complicated to assess, and we'll come back to this with Céline later on. But we could mention one thing already, the exclusion of the imperative mandate acting for the greater good and some role model rules, parliamentary proximity. This is the official objective described officially. So that's what the leaders have to do to maintain the trust with the citizens. But this official objective is partially different from the real objective of the MPs to the represented. By focusing on empirical studies, we can see that the real expectations of the represented are not always the same as the law thinks. For example, the represented expect from their representatives to act in their personal interest or for their category, and not for the general interest as it says in constitutional law. But we also see in studies the importance for the citizen that the MPs keep their electoral promises. But like I said before, the imperative mandate is banned in our system. So transparency, relevance are put aside as opposed to the efficacy of public policies. But and here we need to bring some nuance. The expectations of the citizens can vary. We need to analyze their behaviors, and in reality we see that there's a combination of models that they judge what is acceptable or not for their MPs. For example, Pierre Lascaux, a French sociologist, says citizens are not rigorous legal experts, but they're not also cynical people who want to get their personal interest without ethics. But the proximity issue on which elected representatives work seems to be heard by the citizens and they're concerned. There's also the importance of this proximity could allow, according to some studies, to fight the suspicion of the lack of relevance of MPs. So the proximity of MPs would allow them to personify them by making their critical behaviors or criticized behaviors more commonplace and more commonly accepted. And now Céline is going to tell you about the other trust relationships. The constitutional law, beyond the relationship between represented and representatives, a delegation of power between the parliament and the government, that is done by using the grammar of trust. So the relationship that is thus organized is probably described as a trust relationship because it is inherited from the first MPs, where there was an interpersonal trust relationship from truster to trustees, and we've talked about that before. Now we can see that there is a diversity of practices in terms of trust that can vary a lot between Parliament and government, that go to vague support, absence of distrust, to some forms of interpersonal trust if we look at the relationship between individuals that are in the ministries and the majority. In constitutional law, this trust relationship, and I'm focusing on the parliament regime, varies a lot. There is some written rules and countries where there are no written rules. So in social sciences and political sciences, there are inter-institution trust relationships, depending on the type I'm studying now between the parliament and the government. Highlights the boundaries painters, the individuals that are the link between two institutions. In fact, the inter-institution trust is understood mainly through the trust of the subjective trust of those intermediaries between two institutions. But we can notice that constitutional law, in fact, doesn't frame very much this trust relationship that comes from the borderies painters, and the ministerial responsibility is usually ignored by the formal rules of political life. In Belgium, France, or the UK, the ministerial responsibility was less concerned by the rationalization movement that focused on the trust relationship between the parliament and the government. On a different step, the role of the group leaders is also ambiguous. We consider typically that the objective of this trust relationship is the statement of general politics, the politics that have to be carried out, and the view, which is the objective of the trust relationship between the parliament and the government. But this definition raises at least two questions. The first one is about the relationship of the official objective of trust stated, for example, the governmental statement in Belgium, and the real objective, political objective, the agreement between political parties or non-public agreements. It's obvious that an important part, and maybe the most important part of this trust objective is reluctant to be locked up into legal systems. Some developments lead us to think that the trust between parliament and government is more based on the powers that are granted, which are the objective of the theories of political responsibility, but it's based on the idea of accountability, respecting some ethics. Of course, the ministerial responsibility principle always involved some obligation of truth and sincerity to allow the good functioning of the system. The ministers have to answer the questions of the MPs. But what we seem to see is that the trust is more broadly linked to the notion of integrity, sincerity, truth, role model of the government and their members. So we have to be careful about these developments, because accountability, respecting integrity, transparency, truth are not enough in a parliamentary democracy. The key principle of political responsibility is based on the powers granted, and not just respecting the ethics or the powers granted. So that can be an interesting step, but not enough. In conclusion, the parliamentary regime was built initially based on interpersonal trust relationship, and that the trust appeared as a practical need quickly, and this trust is a way to justify the power applied, and so this is a prerequisite of a trust relationship. So we do as if there was this trust relationship, and if we compare this to the empirical documents, the issue of knowing whether there is a real trust relationship is not always clear. Last, trust relationship is the relationship between the government and those governed. So this is the last defined. So this trust relationship based on the constitutional law is supposed to be taken care of by the political responsibility indeed, it is this mechanism that is supposed to be the immediate guarantee of the trust relationship built indirectly. But more broadly, and I refer to what the Professor Baratas has just said, we have to consider that the trust relationship between the government and the citizens is framed by the rule of law and the human rights. So all the powers have to comply with those rights, and that allows the citizens to trust them, at least in the fact that they will not be subject to arbitrary powers. So this allows the citizen to guarantee the trust he placed in the state. So I will finish by this trust relationship by saying that it's broadly undetermined, and the networks multiply the rules and ethics, and the effects are difficult to assess. So now I would like to move on to the effects, and our second part, the role of the constitutional law in building trust.
La tendance ces dernières années à réinvestir la question de la confiance.
As we have seen these last years, we reinvest the issue of trust through standards with integrity, transparency, and other related issues. So we need to determine to what extent constitutional law could potentially, bearing in mind, of course, the fact that potentially it is likely to contribute to strengthening this trust relationship, which might have been damaged. And we know that we need this source of trust, and we also need to insist upon the fact that all types of trust are not good to be taken into consideration, because some types of trust is not to be considered as valid. For example, the approach according to which we try to please certain groups of the population is not a kind of trust which might be taken into consideration. So we need to sort out the different types of trust in presence. So I will not come back here on the normative grid we deduce from Claude Alps. We will leave this to a more to a written approach. But first and foremost, I'd like to give the floor back to Lena for the rest of the presentation, for the second part. Yes, second part of the exposé. What about the role of constitutional law in building trust? Well, I mean here the trust between those governed and those governing. And I will refer here mainly to the impact of political ethics on trust. As mentioned previously, a few minutes ago, actually, it seems that here we have a political vision of trust which is much more based on the integrity of the governing representatives, while from a political point of view, the different types of trust might be of equal importance, and the notion of trust might be much more important than the notion of integrity. We did refer to political ethics, and we know that governing bodies will refer mainly to the notion of truth. We should have explained that previously with Céline, but we assume you understand what it is about. But we know that we do not measure the impact of political ethics on these rules. The first perverse factor, I would say, is related to the fact that for citizens, what is to be considered as granted, i.e. the fact that governing people need to be trustworthy, is something which might induce some distrust, simply because people will consider it is not deemed to be natural. It is something which has to be induced with a view to be fully implemented by the governing representatives. There is another counterproductive effect regarding those rules. If we adopt a series of rules, and if we have a system which might allow us to check whether or not they are fully compliant, we might induce some abuse. If we have standards with a view to punish some behaviors, it is obvious that those behaviors will be pinpointed in the case of controls and checks. And if we focus on the integrity, and if we are lacking standards, scandals might arise, and we might have more problems in those states where we have more controls. And this might give a kind of illusion to the ordinary citizen, i.e. the fact that those countries where a political ethics is in place are less trustworthy, less honest than those where such rules are not applicable, because sanctions might lead to greater suspicions, if I may say so. Another counterproductive element is that when you do have rules, you sometimes try to bypass the rules or adopt some behaviors with a view to escape those rules. And we might have more political rules or more rules of ethics with a view to go against those abuses. So political ethics or such rules might get multiplied. That's the case in Belgium. We have different rules in different places, and we also have increased expectations regarding the governing representatives. And because of the increase of those rules, because of the fact that we can unveil more and more abuses, we believe that it would be like a fireman who would set a fire, you know. So I think that we need to determine here what is the role of the constitutional law regarding the building of trust. And here I would like to be a bit less negative. We should not lose sight of all the rules which might strengthen transparency, the need to avoid conflict of interest, etc. The purpose is to avoid some abuses and create therefore some distrust. But the impact will be genuine if we manage to anticipate such behaviors and avoid such behaviors. So the rules will only favor the trust if policymakers abide by the rules. But if it is not the case, we will need sanctions, and sanctions which are fully implemented. So now I'd like to give the floor back to Céline. Well, regarding the trust between Parliament and government, in empirical studies we can see that the trust in the role of control at the level of the Parliament goes hand in hand with the role played at the national level. So empirical studies and surveys insist upon the fact that we need to clarify the notion of trust, we need to strengthen the mechanisms of monitoring, and we need to focus a lot on accountability. Well, that's not really what was at the very heart of our debate on the political rule, at least when we had such a debate, which has not always been the case. The rational approach was to have a more stable situation, to have something stable and trust relationship are two different things, as you can guess out of the previous statements we made. So we have some grey areas in Belgium where the government is in a position to lead without any trust. There is a distance between trust and accountability, and we know quite a lot about that, believe me, in Belgium. We also need to bear in mind the fact that what happened in the past did not strengthen the accountability from a ministerial point of view, and this did not always favor good and stable trust relationships. And the code of ethics of the governing leaders is not sufficient, does not suffice, because we cannot cover the whole spectrum of political responsibility. So we need to clarify the political responsibility, and this might be an avenue to explore if we want to restore further the trust. And we will refer to that tomorrow. And then what about a relationship between the governed and the governing people? So we need to have more truth, more sincerity, more transparency. It might appear to be a very good idea, but there might be some paradoxical elements. We should avoid adding more complexity to the existing complexity and make things difficult to understand and to make it difficult for people to fully grasp what is at stake. And then we would like to draw your attention on one element in particular. Those rules do focus on the notion of trust according to the theory, which is opposed to the values related to justice. But that's not sufficient either, because what matters is the responsibility at the level of the power granted. Therefore, what might contribute to strengthen trust would be the strengthening of reactivity and the possibility to have a better interpretation of the situation. So in conclusion, I would like to insist upon the fact that on top of all these elements we have determined, we might have a kind of a double approach. First of all, we need to refer to the role of constitutional law in the political relations, in the political arena. The best possible way for constitutional law to be involved in the management of this trust crisis, it would be to avoid a certain representation, but focus on the foundations of political institutions. Well, let me explain what it means. The literature about a constitutional law do refer to elections, to this notion of authorization we might give through elections. We have the mandate and the trust. These are two different issues, and the analogy might create a kind of vicious circle, because we would reduce everything to elections and authorizations, and this might lead to a trap. And I would like to refer to what Samantha Besson said, because we would consider, therefore, that the representation relationship as a matter of decided trust, which is not always the case, because sometimes we are faced with different types of or practices in the field of trust, and we would overinvest the relation between the governed and the governing bodies. And once again, I would like to refer to what Samantha Besson said about that. This would mean that this trust relationship would be considered as engraved in stone, without referring, for example, to this notion of reciprocity and this notion of circles of trust. And this oversimplified our representation. And this led to a kind of crisis and ultimately to a trust crisis. And once again, I would like to quote Samantha Besson. We have built and rebuilt this notion over time. That's why it is important to promote participation and regular interactions between those represented and those representing them. Therefore, constitutional law could potentially strengthen trust if we go deeper into this notion of control, monitoring, authorization, and accountability through participation, through deliberations, through a better dynamic approach at the level of those governed and those governing. So something which would not be submitted to any evolution. And this might have a positive impact on trust. And a survey of OECD in 2024, the one about trust towards political representatives, did highlight the fact that the participation of citizens in political life was one of the trust determinant regarding the citizens. But several investigations carried out did insist upon the fact that some people feel they don't have a say regarding political issues. Empirical surveys, which were challenged, by the way, but I would like to mention them, one about American politics, insisted upon the fact that people do consider that we've tried to favor one category of the population. And according to this survey, we can see that political decisions do align with the preferences of the wealthier. Mutatis mutandis is another survey carried out in Germany, and the conclusions were exactly the same, although constituencies are quite different. So if we try to benchmark both surveys, we need to consider that it is important to refer to the autonomy of each and every one, and to have some elements related to accountability and monitoring through participation and deliberations. Another element has to do with the fact that constitutional law has to be part and parcel of the whole process, which might help us to make differences. And this might also be important and feed in the element of trust. That's why it is really important to stay firm on the compliance with rights and human rights, because it is key to avoid any feeling of distrust. And the very last point I would like to raise is related to the theory of Klaus-Hoff. It is true that we have focused quite a lot on this notion of truth as being a prerequisite for political trust, but we haven't focused so much on this notion of justice. And this does raise two questions I would like to share with you. In our debates about trust, we need to consider in which way constitutional law might promote equity, equality, fairness. And the second point is the following. Maybe we need to have another interpretation of trust through the institutions and determine whether the institutions have the capacity, the ability to embody those notions of trust and justice. And if we could think it over, this might reshuffle a little bit the debate about those economic and political issues. But I will leave you with those questions if you don't mind.